everybody. Welcome back. I'm Lee Wright, and I am a divorce coach, and I'm so glad that you have joined us at Seasons Ebb and Flow. This channel talks about everything related to divorce, healing, growing, and working through the process. And today I'm excited to say that I am interviewing Thomas Marks, and he is a divorce attorney and he's with the Marks Law Firm. And we are going to be talking about the collaborative divorce process. So, Tom, thank you so much for being here. Can you just tell us a little bit about your background, what you do, and then we'll get into the rest of the interview.
Okay, sure. Lee, thank you so much for having me on your channel. I'm a family law attorney, been doing this for 38 years, believe it or not. Actually, March 1st, we just celebrated our 32nd year of starting the firm. So we had a little anniversary there.
Nice.
Um, so I really started doing family law because I was low man on the totem pole, and I was at a firm where none of the senior guys wanted to do family law, and none of them wanted to touch it with a 10-foot pole. So they said, give it to Tom, he'll take it, he'll have to do it. And I loved doing family law. I love my clients. I enjoy the personal interaction. Yeah, I've been doing it for over 35 years. I did a little bit of other law practice before that. But I do exclusively family law now. I've done a lot of family law litigation over the years, but about 15 years ago, I started doing collaborative law, and I've seen the benefits of it and how much better it can be than the traditional litigation model. I've really started expanding my practice and doing more and more of collaborative practice.
Nice. So, can you explain to me the differences and the benefits of collaborative and how it differs from that litigation model?
Yes. So litigation model is something what we call the traditional litigation model, where the parties hire attorneys, they quote unquote lawyer up, and they file a petition for dissolution of marriage, and then there's an answer and a counter petition and mandatory disclosure and maybe depositions and hearings. And
Mhm.
unfortunately, it can be very destructive to the family because they end up having to try to show how terrible the other parent is in order to get a leg up, or to get if it's a custody battle, so they get more time or whatever, or they try to show there's been a waste of marital assets and some bad behavior of the other parent. And then unfortunately, in the litigation model, they end up oftentimes just hating each other, unable to communicate, unable to co-parent well, and it's really harmful to the children. So conversely, in the collaborative process, it's a voluntary process. So the parties have to agree. They have to sign a collaborative participation agreement that
Hmm.
says, basically, we're not going to go to court. We're going to be transparent in the process. We're going to not hide the ball. We're going to express what are our common goals. So there's no going to court. You're set within the collaborative process. You'll have a team. Each client has to have a collaborative attorney under the statute. And then oftentimes, most often, you'll have a mental health neutral and a financial neutral. And they'll do a lot of the things that the attorneys otherwise would have done, but probably for a lower cost and more effectively or efficiently, because financial neutral is typically like a forensic CPA that can very easily put together child support guidelines and alimony analysis and equitable distribution worksheets. And the mental health neutral helps the parties put together a parenting plan. So the
Um,
attorneys are more advisors and facilitators and encouragers through the process.
okay. Oh, that's really interesting. I never thought about the fact that if the attorney's not doing some of those financial or parenting plan pieces, that you're saving time if the others are less expensive. And more expertise in those
Yeah.
areas?
So typically the attorneys charge more per hour. And so if it took them, even if the attorneys did it in the same amount of time, the financial neutral is going to charge less per hour. So it's going to cost less there. The mental health neutral charges less. So typically family law attorneys make less money in a collaborative case,
Mm,
but the results are often so much far superior. I can't tell you how many stories I have of like even the other side. We don't call the other attorney opposing counsel in a collaborative. We call them collaborative counsel, and we don't
okay.
call the other side opposing party. They're just, the mother or the father or the husband or wife, or you can have paternity, or you can have a prenuptial agreement through a collaborative process. But most of them are dissolution of marriage, better known as divorce. But I'm going to tell you, like, I have received photos of the, let's say, mom that I didn't represent. It went so well during the process that she'll send me photos of her and the kids at Christmas. Kind of
Wow.
crazy. You will not see that in litigation. It just
No,
doesn't happen.
right.
Yeah.
Absolutely. So that's the kind of differences. What are, do you believe, the benefits um, of using collaborative?
So, okay, probably the number one benefit is that especially moms and dads that are going to have to continue to go on for many years forward, co-parenting the children, improves communication, lowers the animosity,
Mhm.
increases the amicable willingness to work together, all those kinds of things. And the result is more tailored to what the two parties really want to accomplish, instead of putting it in front of a judge who's just going to broad brush it and say, well, we're just going to sell the house. I don't care one party or the other wanted to keep it, or we're just going to do a standard time sharing schedule. We don't care if it could have been more flexible. Judges don't have really the time or the ability legally to tailor things like you can do in a collaborative case. So the benefits are there's so much more flexibility, so much more peaceful resolution. But there's some other factors like collaborative is way more confidential. You don't have to file the financial affidavits in the public record. You don't have to file the equitable distribution worksheet, the child support guideline. So it's not on the public record what
Mm,
the party's assets and debts are. It's not on the record how much child support one party's getting or how much alimony they're getting. So I think it's kind of safer that it's not on the public record how much money is involved and who's getting what.
right. Oh, that's very interesting.
Yeah. And one last thing, I would say that collaborative is way less expensive than a full blown litigation case by
Yeah.
far. Um, and the results are often, I would say almost always, I guess my experience, yeah, almost always better than litigation just because of the flexibility and what the parties really want to accomplish.
Mm.
So, yeah, it's really better for mom, dad, and the kids.
Okay, great. So just another question kind of related to the difference. Like in Florida, with a traditional litigation divorce, you're required to do mediation first, and hopefully the majority of cases do complete in mediation. They have a mediator along with the two attorneys. When you're doing collaborative, is it the two attorneys and a mediator and the two neutrals, or no mediator is necessary because kind of the attorneys are acting as mediators?
Um, well, in collaborative, the vast majority never need a mediation. It's only if at the end of the collaborative process we're kind of stuck. There
Um,
is the possibility of bringing in a collaboratively trained mediator, but I would say 90 plus percent of collaborative cases do not need mediation.
wow.
Now, in the traditional litigation model, yes, the judges have required that all the cases have to go to mediation. Why? because, yeah, a good percentage of the cases are going to settle in mediation. So the judge never has to deal with them. It kind of like saves the judges a lot of time and effort.
Yeah.
Um, but the mediation comes only after the petition is filed, the counter petition, answer to the counter petition, all the mandatory disclosure is done, any other discovery, request to produce, interrogatories, all of that has to be in place first. Then they go to mediation. It's probably the earliest it's going to be is 3 months to
Mm-hmm.
maybe as far out as 6 months after it's filed. So,
Mm.
whereas collaborative, the shortest collaborative case I've ever settled is one meeting.
Wow.
The average is 3 meetings, maybe four.
Oh,
I've had a couple that have gone longer, but the sweet spot is 3 or 4 meetings for a collaborative case, and you're done.
wow.
Yeah.
And do the neutrals meet with each party individually or with the two parties together? And are the lawyers there when the neutrals are meeting with them?
That's a great question, Lee. Um, it can happen a myriad of ways. It can happen with both parties together. It can happen separately. It can happen with the attorneys there or not. I typically pick um, the neutrals, the mental health neutral and the financial neutral that I know are really competent and really high integrity and quality. I'm going to review everything
Sure.
anyway. So I don't feel like I need to be there at the meeting with them. I don't need to charge the client for that. I
Yeah.
will prep with the client before they meet. Let's say I'm representing mom or dad. It doesn't matter. I'm going to meet with them before. They're going to have a meeting, maybe together, husband and wife, with the mental health neutral to talk about the parenting plan. So here's the time sharing schedule. Here's all kinds of very unique details that they can get into a right of first refusal. If one parent's not going to be physically able to be present with the children, do they give the other parent the option to take care of the child rather than leave with a babysitter? Um, what about extracurriculars? What about holidays? What about out of state travel? What about, special times in the summer? Everything's unique because some people like Christmas is always a big one, right?
Yeah. Yeah.
So some clients, their tradition is Christmas Eve, and the other one doesn't care that much about it. So instead of just splitting everything down the middle,
Mm.
one party might give the other spouse Christmas Eve every year, and then maybe the other spouse gets something special on Christmas Day. I mean, so there's a lot of flexibility and ways to work it.
Yeah. Okay. And who chooses the neutrals? Do the two lawyers agree on which ones they want to use?
Yeah, so typically the parties come in. So every family law case under the Florida Supreme Court's rules, every family law attorney is supposed to talk to their clients about collaborative to give them that as an option or an alternative to the traditional litigation model.
Oh,
So I find oftentimes, I hate to say this, but I'll have clients come in oftentimes who've met with another attorney before me, and I'll say I'm sure you're aware of collaborative, and they're like, no, I've never heard of it, and I'm like,
oh,
oh, okay, well, and then I'll tell them about it. And invariably they'll want to do collaborative for all the benefits we talked about previously. um, so yes, the clients typically come to the attorneys first, and then the attorneys communicate and mutually pick the collaborative team, a financial neutral and a mental health neutral.
okay. That's great. So thinking about originally I thought, oh, you're involving more professionals. It probably is more expensive, but how would you compare the cost of collaborative versus litigated divorces?
Okay. So pretty much as I said before, collaborative is typically going to be far less expensive than a litigated divorce in the sense of if say it's a custody battle and it's going to go to trial, it's going to be way more expensive. Um, However, if the parties have a simplified case let's say there's no minor children, there's no significant assets, no one's has a privately held corporation or business, they're not self-employed, they're like W-2 wage earners.
Yeah.
Those cases have a very high settlement rate. So I would say cases like that, it can settle at mediation or even before mediation. I will oftentimes with my client put together a marital settlement agreement before we even file the petition, but certainly before we go to mediation and send it to the other side. And we typically resolve it either before mediation or at mediation. And I'm going to say probably those cases would be less expensive than collaborative.
Okay. Yeah, that makes a lot of sense. So for some people, it makes sense to avoid. So in those cases that are very simple and you might, finish the settlement before you even get to mediation, those people hire you as an attorney, the one side, and they have an attorney on their side, but you're working collaboratively still. It's just not, it's more amicable, but it's not using the collaborative format.
Yeah, exactly. It's what I call collaborative with a small c rather than collaborative with a capital C. Capital
Right.
C is you're following the precepts of the statute that the
Yeah.
legislature's passed. Small c says you each have picked a lawyer that's actually going to do what's in your best interest and help you work it out amicably and not make it into something that it shouldn't have to be. I will
Right.
say this, I often get clients in whose spouse doesn't really want to pay for an attorney. So we do the work of putting it together. I draft my settlement agreements in plain English. They're not in Latin. Everybody can understand it. The other side doesn't really need well, that's up to them. I can't give them legal advice.
Right.
Oftentimes they don't hire an attorney because it's pretty straightforward. But they have the right to take it to a lawyer for like a 1 hour consultation just to look at. And oftentimes it just goes through and they save a whole lot of money.
Yeah, that makes so much sense. It's pretty straightforward. It just seems like it shouldn't have to cost $10,000 or more to if you can agree very easily.
Yeah. I mean, I have seen litigated custody cases in Orlando cost into the six figures. And I've seen, yeah, it's can be very expensive. Collaborative, obviously, is way less than that, depending on the number of meetings. Every meeting is an expense. So
Mhm.
the clients often realize that and they go, okay, well, let's get this done because we're doing it amicably. And
Mhm.
what's there's nothing to fight over because we're what's really kind of cool about collaborative, what I really like is in the very first meeting, the clients tell the mental health neutral what their goals are. So
Mhm.
let's say I'm representing dad and he says, I want to protect the kids from the litigation process. I want to make sure that they're well adapted and healthy. I want to make sure they're doing well in school. I want to make sure that we don't spend all our money on litigation so that we can put money aside for their college fund. And
Mhm.
then mom gets up there and says, I want to protect the kids from litigation. I want to put money aside for their college. So then all of a sudden, their goals are the same. And then
Yeah.
it's kind of like sometimes it's like singing Kumbaya and we move forward very quickly.
Yeah, that's great. I think it would be so nice if every divorce could be more like that because if you can co-parent well, if you haven't destroyed the relationship as a war during the divorce, like it is so much better for the kids and for both parties' long-term mental health. And so, yeah,
Yeah. And you probably get a chance to talk with your clients a lot about the benefits of collaborative versus litigation.
yeah, I always speak about the importance of trying to do it amicably, whichever process you choose, whether it's collaborative or going through mediation, ensuring that you have attorneys who are not trying to escalate things. And, for families, for couples who have children, I just keep saying to them, as long as you keep your kids front and center in your minds, then chances are you're going to make the right decisions for your family.
And
So,
that's really good advice. And what the statute says is the parties should be doing what's, quote, in the best interest of the minor children.
yeah, it makes,
Yeah.
yeah. Um, what about in these situations where, let's say hypothetically, the husband or wife comes to you and says, I want to do this amicably. My soon-to-be ex is really difficult. Like, I would classify him as a narcissist or her as a narcissist, and I'm dreading going through the divorce because I just don't feel like they're mentally healthy. And so, but do you think collaborative could work in situations like that when one of the parties is, kind of, you never know when they're gonna lose it?
Right. Yeah. Well, I mean, having done family law for over 35 years, I've seen every variation of personality disorder, whether it's narcissism or borderline personality or
Mm,
histrionic or whatever. Um, yeah, I think it can work. And what's actually really great about the collaborative process for cases where you have one of the parties that is has a personality disorder, you have a mental health
mm,
professional. You have a mental health neutral, typically can be a licensed mental health social worker, therapist, PhD psychologist. So they know how to
mm,
work with people like that. Obviously, I've had to deal with those types of individuals for a lot of years. And, I always say to myself, what is it that a narcissist really wants?
uh-huh.
Right? What they're
Mm-hmm.
really interested in is what they want. So it's not a bad question to ask them what they want and to give
Mm,
them some psychological air, let them talk a little bit, let them
right.
feel heard, and then they'll let their guard down some. Some are harder than others. I get that.
Mm,
But ultimately, after they feel fully heard and they've
mm,
gotten it out, then they're more open to hearing what, their spouse might want. And
mm,
so I got that from Stephen Covey's book, Seven Habits of Highly Effective People.
yeah.
His fourth habit is seek first to understand and then to be understood.
Mm,
So, and the whole psychological error thing. I mean, yes, I'm a family law attorney, but I've learned a lot about psychology
I
over
bet.
the past 3.5 decades.
Yeah, I'm sure you have learned different ways to navigate challenging personalities for sure.
Yeah. And I'm sure you have too.
Yeah, yeah. It's interesting as you learn what works with different people, and everybody has their things that they need that are different from someone else, and just understanding that is very helpful.
Yeah, absolutely.
What about the success rate of collaborative getting to the conclusion? Is that uh, any different to litigated divorces? You said sometimes they're a lot faster, but do some of them, I guess I'm guessing some just can't come to conclusion and then they have to change course away from collaborative?
Yeah. So, for personally, my success rate is right around 95%. I mean,
Wow.
it's unusual for a collaborative case to fail.
Okay.
And another good thing about collaborative, I probably didn't say before, is that everybody is invested in the success of the collaborative process.
Mm,
Both attorneys are invested in the success. Both neutrals are invested in the success. And some people see this as a great positive, and some people can see it as a negative. But the statute says that the attorneys have to agree, if it's a collaborative case, to withdraw if it fails and
mm,
not go forward with the litigation. Now, the
uh,
reason for that, the Florida Supreme Court put in there, or the legislature, was that it wanted to remove any incentive of
mm,
the attorneys to cause it to fail so that they would make more money in litigation. Now, that
Brilliant.
would be unethical. Lawyers are not supposed to do that. And I would hope and pray my colleagues would not do that. But that takes away any incentive of the attorneys to not want it to succeed.
Yeah,
There is
absolutely.
another, I should just say, there is an offshoot of collaborative that looks identical to collaborative, and it's called cooperative. It's not actually fully under the statute
Mm,
like collaborative is. The attorneys don't sign the disqualification clause that
mm,
says they have to
pull
withdraw if it
out.
fails. In a cooperative case, the attorneys may stay on if the
It
cooperative
falls
case
through.
fails. And
Uh,
sometimes clients get very attached to their attorneys and they don't want to lose them.
yeah.
And the client wants it to be cooperative. Sometimes the
Mm,
attorneys want it to be cooperative.
okay.
I've done both, and surprisingly, the cooperative cases settle as much as the collaborative cases, in my
Okay.
experience.
Nice. And the cooperative also still uses the financial and mental health neutrals.
Yes, and
Oh.
all of my really, yeah, all of my cases, I use both of the neutrals. Technically, under the statute, the statute only requires the parties to have collaboratively trained attorneys.
Mm,
Um, and doesn't require the neutrals. However, I think the neutrals are of great benefit. And as I said before, are cost savings to the
mhm.
clients because they can do the things for less money. I would be open to doing a collaborative without if the clients insisted on it, but I do encourage the clients to have the mental health and the financial neutrals.
Mm. And the financial neutral, do they just focus with the clients kind of on how to split assets, or do they actually even work with the clients on when this is done, this is what your budget looks like, this is, what you can expect with what financial situation you're going to be in post-divorce?
Yeah, so the financial neutral can do a financial affidavit for each client to see what their expenses are and compare that to their income, assets, and liabilities too. And they can also do like what's called a lifestyle analysis, and that's often
Mm,
done in terms of alimony. Like what is their need going to be after the divorce is final for spousal support or alimony. So let's say, well, let's flip it. Mom makes 10,000 net a month, and dad makes 2,000 net a month. Probably going to be some alimony there. We have a new statute in Florida. The legislature passed July 1st. The governor signed. It's been in the works for years, where the legislature did away with permanent alimony. So we don't have permanent alimony
mm,
anymore, but it enshrined for durational alimony a formula. And so we can use that formula now. We've never had a formula in Florida
yeah,
for statutory alimony, and I could get into the details, but probably beyond the scope of this.
sure.
Um, but the financial neutral can use that with the lifestyle analysis, with the financial affidavits to let's say, the parties both know how much money they're going to need to cover their expenses in the future.
Right. Yeah, that's so important. I think
Yeah,
setting your expectations, like especially the first few years post-divorce, it's going to be an adjustment for many people.
yeah.
And
And there's a savings to the clients too, because instead of the husband hiring a financial expert and then the wife hiring a financial expert and then them having different opinions or
yeah,
whatever because of who they represent, and then maybe having to file to hire a third financial expert, you avoid all that happens in litigation, and you just go with the one financial neutral. And I'll say this too: the financial neutrals are neutral in the sense that they don't give advice to either client. Only the lawyers give the client's advice, and the neutrals, um, what they learn in the case is not confidential. What their attorneys learn in the case is confidential. And
Mm,
then finally, the neutrals are not allowed to continue on representing either client after the collaborative case, because that
mm,
would have shown maybe some bias. So
right.
they, if you have a financial neutral that deals with selling financial products, they can't sell financial products to either client after the collaborative case,
Mm. And
unless there is an exception. I hate to get into the weeds, but there's so
no,
many
that's
details.
great.
There's something called allied professionals.
Uh-huh.
Allied professionals are not the neutrals. They're brought in addition, believe it or not, some cases might bring in a realtor or a divorce coach
Right,
or
right.
a financial advisor who then, yes, that person can come in and still sell products or represent the clients after the collaborative, but not the neutrals.
Okay. That's very interesting.
Yes.
And then, so do the two lawyers and the two main neutrals meet together alone without the parties just to go over the details and or if there's a sticking point, or is it or anytime there's like a meeting with all parties of the professionals, are the clients participating?
That's another great question. So, there will typically be a professionals call, meaning the two lawyers and the two neutrals, just before the first collaborative team meeting, which includes
Um,
the clients, to
right.
prepare for it, to figure out what are the issues. The financial neutral will then end up meeting with the clients before the first collaborative team meeting and
Um,
getting the documents they need to present the equitable distribution worksheet or whatever they call it. They have different names for it. I call it equitable distribution worksheet.
sure.
Mental health neutral will meet then with them before, but in every collaborative team meeting, they're typically 3 hours. The first half hour is the professionals meet for that 30 minutes before the full meeting to be fully prepared for all the issues that are going to happen. Then the clients show up for 2 hours, and then the professionals meet for the last 30 minutes to debrief and to make plans for what's going to happen before the next meeting.
Okay.
There is one other person, believe it or not, that I often recommend to the clients and the team to have at the collaborative team meetings, and that is a quote note taker. They are
Mm,
free. They do not charge for their
mm,
time. They're learning. It's an opportunity for them to see a collaborative case. They may have never have handled one, and they want to get an experience to see what it's like. So they're going to volunteer their time. They're going to take all the notes from the meeting. So it frees up the lawyers and the neutrals to focus on what they're doing rather than sitting down taking notes. So
right.
then the note taker will type them up, send them to the team. We all look at them, make whatever adjustments are necessary. And it's a thing of beauty because
Yeah.
I really don't like taking the notes during the meeting because I want to
Yeah,
focus
you want to
on,
be able to really focus and keep everything moving and converse and notice the
yeah,
nonverbals and anything like that, which,
yeah.
hmm,
I hope I'm not giving too much detail because I know it's a lot, right, to take in all
no,
this.
I think this is so helpful. People, I think the hardest part about divorce, since most of us haven't gone through it, is it's like a black box that you have no idea what to expect. And the more you know, like knowledge is power, and the more you know what to expect. And so I think sometimes the details, like people might get a little overwhelmed, but at least they know what to expect. And so that's why I feel like a channel like this is really helpful to provide the details behind the scenes so that people can make the best decisions for themselves.
Yeah, that's really such a great point because I always meet with my clients before the first collaborative team meeting to kind of paint a picture of what to expect. I even say where everybody's going to sit. It's going to be in my conference room. There's going to be an easel over there with this oversized post-it note thing that, we're going to write your goals and your spouse's goals. And then you pull those up, they have a sticky on the back, and you stick them on the wall, and we'll have them at all the meetings. And so the goals are one of the most important things to really consider, because it sets the tempo for the first meeting. And if you can get agreement on the first 3 or 4 goals with your spouse, it
Mm,
just helps facilitate the process and helps reach a settlement that much more quickly.
nice. Well, I will say kudos to you for doing such a good job preparing and giving them a good expectation of what the meeting's going to look like. And because I will say, I don't think all lawyers do that. I don't feel like there was a lot of expectation setting or picture painting for me, and a lot of my clients feel like they're not getting enough information or expectation setting. And then again, you feel like you're navigating in the dark. And so I think great lawyers obviously do a good job with that, but there are a lot of people who don't get that. And, it's just, it can be very confusing and overwhelming because you just are like showing up to meetings and you have no idea what to expect.
Yeah,
So,
I really believe in practicing the golden rule. I mean, do unto others as you would have them do unto you. And that's how I would want to be treated. I would want to know what to expect. I would want to know that my attorney really cares about me. I would want to know that they're going to communicate. They're going to return my phone call if I have a question, or if I send an email. Because the worst thing for a client is to be out in the dark and to
mhm.
feel like they're not getting responses. I often say that to a client, like if they call you, it's almost like every minute they're waiting for a response is like an hour. Every hour is like a day. Like every day is like a week.
Yes.
So
Yeah.
my goal is to get back to every client every day before the end of the day. If I haven't gotten back to the client by the end of the day, I'm going to call them on my way home. I'm going to make sure all my calls are made, taken care of. So then when I walk in the door at home, hopefully I can give my attention to my family and actually disengage a little bit. I
Mm,
will admit I do check emails at night too, just
mhm.
because I don't want clients waiting until the next morning. But I do have some boundaries there. I like to have some healthy boundaries, but I
Yeah.
do really, put my clients first, I guess, and I
Mm,
try to do how I would want to be treated.
that's wonderful. Yeah, boundaries are important, but it's really nice to uh, put yourself in the shoes of what the clients are feeling and try to give them the support that they need as fast as possible. It's great.
Yeah.
Um, I thought we could close with when you talked about giving your family attention and your own hobbies. We've talked a little bit about your interest in horticulture and growing fruit. So I thought it'd be nice for you to tell us a little bit about your personal hobby and why you love it and what that looks like.
Well, great question. I love to talk about this topic. I mean, I think it's really important for lawyers, for everyone, to have other interests or passions that really fill them and, in some sense, complete them and bring joy into their lives. So, I have always loved working outdoors. It's almost a little embarrassing, but I have 26 avocado trees in my yard. Um,
Wow.
yeah, and I have a total of about 80 fruit bearing trees in my yard. I know it's crazy.
What
Um,
do you do with all the fruit?
well, I give them to my clients. I bring them to collaborative meetings. I give them to my team here at the office.
Nice.
Um, I just enjoy growing them, and
Mhm.
like avocados. Okay, like most people think, I'll ask them how many different varieties of avocados you think there are. And a lot of people say, well, there's two. There's that big green one and the little pebbly one or whatever. Um, Honestly, there are over 1,000 avocado varieties worldwide, believe it.
Whoa.
So I have 22 different varieties of avocados. My goal is I picked varieties that produce at different times of the year. So my goal is to have avocados year round. I actually have them on a spreadsheet. A lot of my trees are younger, so they're not producing. Last year I had 7 trees producing. This year it looks like I may have 14 trees. So it's
Wow.
double. And little known secret, I just bought 2 new avocado trees in pots that in the spring I'm going to plant. So I will have 28 avocado trees in my yard. Yes.
Nice. Well, you must have a pretty big yard in order to have that many trees.
Yes. And I don't have much grass left because it's mostly trees now, but it's something I really just enjoy. And really, the trees aren't that much work. Once you get them established,
Mm,
it's not like growing vegetables that you're always weeding around them and
no.
stuff. I do mulch them and fertilize them, but it's really not that much work.
Yeah. Yeah, talking about something that brings you joy, that's really something that I work with my clients as they are coming out of a divorce, like to reconnect with themselves and find whatever it is that brings them joy, whether it's gardening or dancing or, you know, learning an instrument, but something that either they've always wanted to do or used to do and it fell out of it. And, just remembering that you can bring yourself joy and you need to find those things again.
Yeah, absolutely. Another thing I just find joy in is I have a boxer dog, and he's
Uh-huh.
my seventh boxer. I've had boxers my entire life. He's always with me in the yard. He's always ready to go for a walk. He's always,
Yeah.
wanting me to pet him.
Sidekick.
Right? And having pets is, well, I have a cat too. I had never been a cat person until my daughter and my wife started wanting to have cats. And so now we have 4 cats in the house. And
Oh
one of
my
them,
goodness.
yeah, one of them for some reason has picked me and wants to be on me all the time. So
Oh,
I guess I can't deny it anymore. I guess I'm a bit of a cat person too.
yeah. I think once you end up having a good cat, you kind of change if you think you don't like them.
Yeah, for sure.
Yeah. Yeah. So, if people who are watching want to get a hold of you, how do they reach you, or where can they find more information?
So probably the best way is just to call the office. It's the Marks Law Firm. We're just north of downtown on Magnolia Street. The number's 407-872-3161. I hardly ever give out the website, so I always have to look. It's www.markslawfla.com. That's Marks lawfla.com. We have a website. You can see that. We have a lot of 5-star Google reviews, and we have. I actually started a YouTube channel during the pandemic. I think I shot about 130 videos. So I have a lot of videos on topics for clients. A lot of my existing clients really like to watch them
Mhm.
because, like, I have a 4-part series on the 20 factors that the court has to consider in a custody case, and
Mhm.
broke it into 4 videos, each focusing on 5 of the factors. So that saves my clients, a couple hours of me explaining it to them, and
Absolutely.
so they can watch it for free on my YouTube channel, The Healthy Family Law Attorney, and there's a link to it on our website.
Yeah, and I'll put links to all of these in the description. But yeah, I've watched some of your videos and they're really informative. So I
Well,
definitely
good.
recommend people to take a look.
It was it was something new and different when I started. I don't know how good the first ones were, but I kind of got a little bit more comfortable as I went on.
Yeah,
And
yeah.
I enjoyed it. And I've really enjoyed this too. You've been a great interviewer here.
Oh, well, thank you. I enjoy it too. I like asking questions that I'm really curious about, and I feel like I learned so much just by listening. So,
Yeah, well, you're good and inquisitive, and I hope I provided some helpful information today. So for you and of course your viewers.
yeah, well, thank you so much for your time, and I really appreciate it.
Well, thank you for having me on, and I've really enjoyed myself. Thank you.
Good, good, good. All right, take care.
Okay, you too.